Welcome to Chapter 2 for your Employment Law class. In this chapter, we're going to talk about the Employment Law Toolkit. So this chapter is going to help you understand resources you can use to understand what the law is and recurring legal concepts. As you go into your future careers and your future lives, the important thing you'll get out of these legal studies classes you take in a business program is foundational understanding. You're learning the basics, and you're learning them on a very general level across the whole country. Sometimes we talk about many states do this or some states do that because we don't know where you're going to end up, and you may end up in many different places, or a multinational company that has to be aware of laws all over the place. Some of you may have not taken a lot of law classes before. Many of you have probably taken the basic legal environment class here at West Georgia or somewhere else. And so it's important to take a little bit of time up front to introduce you to some of the helpful information that will make your journey through the law a little bit easier. If you have taken legal environment before, or in my class, for example, we talk about legalese, normal English terms that have specific legal meaning. And so employment law is no exception to that. There are legalese terms that have specific legal context. But I'm going to try to help you, in this textbook, I think, does a really good job of explaining things in plain terms so that you understand really what it's at, because this information is most useful to you if you actually can understand and apply it. And that'll help your journey easier. If you go through the textbook and you see an icon in the text that is the toolkit icon, you know that that chapter is referring to something that you learned here in this chapter in the Employment Law Toolkit, and so you can come back to Chapter 2 to refer to that resource if you don't really understand what it's talking about as you read through the textbook. And also, like reading these cases. The cases in this book are considered an important part of the chapters and the content that we're talking about, but it's important to know that cases change all the time. So sometimes some of the cases you read are the foundation, and that's still currently the case, or it might be something that's kind of in dispute. It's a hot topic. But understanding case law and how to read these things will help you as things change over time, because remember, this is more about the foundation, but it'll help you understand what things are going forward and how they're changing. And this content is as up to date as possible, but things can change quickly in the employment law text and in the employment law context. And so it's important to understand where to go for the most up-to-date current information when you get to your future careers for what really applies to you and your industry right in that moment. So just to quickly look at the learning objectives for Chapter 2, understanding how to read cases and citations, and some of this might be familiar to you again if you've taken other legal studies courses. Explaining and distinguish the concepts of stare decisis and what precedent cases are, evaluating whether an employee is an at-will employee, determining if at-will employee has sufficient basis for a wrongful discharge claim, recognizing and explaining at least 3 exceptions to employment at-will doctrine, distinguishing between a disparate impact case or a disparate treatment case when it comes to discrimination claims, like intentional discrimination versus unintentional discrimination, providing the basis for employer defenses to an employment discrimination claim, determining if there's a sufficient basis for retaliation claim by an employee, identifying sources for further legal information and resources. So again, this is a textbook on the law. This class is teaching you employment law. But the idea behind it is for non-lawyers to be able to really understand this material. People that are professionals in management and human resources. So again, trying to keep that legalese minimized so you can understand concepts in like real plain language. And how to find other information, going forward and as the law gets changed and updated. There's a little interplay between states and federal court system. It's important to remember that in the employment law context, there are employment law statutes at the state level that apply to any particular state, and there's also employment law statutes at the federal level that apply to all of the states in the country. U.S. Supreme Court decisions are final when it comes to the court system, and state Supreme Court decisions are final on most state law matters, unless a state law matter is being contested at the federal level. So again, there's that interplay there. Most of the cases that you'll read about in this textbook are going to involve federal courts applying federal statutes because that's most widely applicable. And when you look at the case, this is the case information, the case name, citation, where to find it, and the outcome of where that decision was made. And again, these decisions that you're reading about in your textbook are heavily edited to get rid of stuff that's not really relevant to what you're learning and kind of get to the heart of the matter so you can understand how it showed up in real life and what was important to that decision. So these are some terms that you'll come across when you're reading cases. Again, hopefully this is more of a review than the first time you're hearing this information, these terms, but we have the plaintiff who brought the action in court. The defendant is the one who is defending the case or the one who the action is against. Appellant brings the appeal. The appellee is the one who's defending against the appeal. The petitioner, the one who appeals the case to the Supreme Court, or the respondent who responds to the petition of the petitioner. That's who the case is appealed against at the Supreme Court level. We have law reporters, that book that you'll find the opinion in, case citation, the volume and pages where you'll find it, and then motions that you might see, motion to dismiss, that's requesting that they reject the plaintiff's case for whatever reason. Motion for summary judgment is a request to rule on the case based on what's been submitted, alleging that we don't have any big issues of facts that need to be decided. Per curiam is the brief determination made by the appellate court not to be issued by a particular judge. Again, we come down to the prima facie case. That's the case that's being built for the cause of action. So there was a right that someone is suing for, the right provided by the law. Someone is suing for remedies because that right was violated in some way. So to establish that prima facie case, they are showing evidence that supports facts of the case to create that cause of action. So depending on what their claim is, there's going to be elements of this is what happened, and I'm showing this evidence to prove this, this, and this element of that cause of action. The plaintiff has the burden to prove these elements of the cause of action, that they have a claim to relief, and the defendant can appear and they have a chance for rebuttal against the plaintiff's claims. They get to answer those claims, or they get to say, well, that happened, but it was justified, and here's my defense of why that's okay, and that wasn't a wrong, that was justified. When someone is, organizing the analysis of a claim, it's important to work through all those elements of the prima facie case, because the plaintiff has the burden of proof, and so they need to make sure they are providing evidence and facts that support every single element, because if they don't provide for every element of that prima facie case, then they haven't made their case and they have that burden of proof. So the concept of at-will employment exists where there's no contractual obligation to remain in an employment relationship for a defined period of time. So at-will employment works for either party. The employee doesn't have to stay working for that employer if they don't want to, and the employer does not have to continue to retain that employee if they don't want to, as long as it's not for they can, fire an employee, or an employee can quit as they wish. They can leave when they no longer wish to work there. It comes from the Old English feudal system and has evolved over time. At-will employment can be the relationship that's terminated by either party. It's not, a lot of times people think that it means, the employer can fire someone whenever they want to, unless it's for an illegal reason. But really, at-will employment benefits both parties because it provides for the freedom of someone to work for who they choose to work for, and not be forced to work for someone if they're not under a contractual obligation to continue that employment. So it's symmetrical. Employers kind of sometimes seem to hold more cards. They have more power because people need their paychecks. They've got bills to pay. So sometimes there are situations where the courts have carved out a few exceptional circumstances that limit that employer discretion on who they can let go and when. So obviously, like, one bad reason for terminating someone's employment would be in violation of the Civil Rights Act protections, in violation of Title VII discrimination protections, things like that. So exclusions for at-will employment, if someone is an at-will employee, then, again, we have that freedom to work for whoever they want to work for. But employees that are covered by a collective bargaining agreement, that would be an exclusion for at-will employment, because they have, a connection to this group that is like a union, a labor union or something that gives them that agreement. In the government, there's federal worker unions. And in situations where someone is wrongfully terminated, it was unjustified, they can sue for wrongful termination and potentially have damages, compensatory damages, to make them whole again because of this wrongful termination. Punitive damages are not as common, but they can exist in situations where it was just very egregious and they're intended to punish the wrongdoer and deter other people from that kind of behavior in the future. States can vary pretty broadly in their recognition of exceptions to this doctrine of at-will employment. Some states recognize just like one or more exceptions, others might recognize none. So it's important, again, to remember there's a state-by-state consideration for these kinds of exceptions to employment at will, because it's going to change from state to state. But it is important to note that, right now, at-will doctrine still survives as the default rule in almost every state. So, there's public policy exceptions to at-will employment. Again, state laws vary widely in what they do or don't allow as exceptions to at-will employment. But the general idea behind public policy exceptions is it's this concept to protect people that are acting in ways that are for the public good, to protect their employment, like termination following someone who's a whistleblower. We protect against that retaliation because it's in society's interest. It's a good public policy that whistleblowers are protected. If somebody is doing something wrong, something that's dangerous, and they report that, and then the retaliation gets them fired, that's not acceptable. And so that's a public policy example of an exception to at-will employment. Again, retaliatory discharge, terminations in response to an employee exercising their rights, filing a claim, charging discrimination, again, whistleblowing, those kind of things, those are protected as exceptions to the at-will doctrine of letting someone go. And a termination resulting as retaliation is an example of potentially wrongful discharge, and someone can bring a lawsuit over that. So in order to prove, a claim for retaliatory discharge, an employee's got to show that they were participating in some protected activity and then there was an adverse employment action towards them by their employer, and there's a connection between their protected activity and this adverse action that was taken. In determining whether that action is sufficient to support a claim, courts are going to look at an objective standard and measure whether a reasonable employee would view that retaliation harm as significant. So here's an exhibit showing, how it breaks down step by step. This is a prima facie case, the elements that need to be proven to provide evidence for a claim of retaliatory discharge for wrongful termination. So the employee participated in a protected activity, there was an adverse employment action, and then show that causal connection between that protected activity and the adverse action. There's also an at-will employment exception to this implied covenant of good faith and fair dealing. This is in the performance and enforcement of the employee's work agreement. This requirement should not be confused with a requirement in some contracts of good cause before termination. So it's more limited than just cause termination protection. This implied covenant of good faith and fair dealing means that any agreement between the employer and the employee includes a promise that the parties will deal with each other fairly and in good faith. This is not widely recognized. There's only about 20 states that recognize this exception. And some states allow the cause of action, but maybe limit the damages awarded to those that would be awarded under a breach of contract claim. Other states allow the terminated employee to recover, higher tort damages. But critics of this implied agreement argue that where the agreement is specifically non-durational, there should be no expectation of guaranteed employment of any length. So you can see that argument that as long as both parties are aware the relationship may be terminated at any time, it'd be extremely difficult to prove that either party acted in bad faith in terminating the relationship. Courts have supported this idea in holding that an implied contract or covenant seems to upset the balance between the employee's interest in maintaining his or her employment and the employer's interest in running its business as it sees fit. So a similar exception is implied contract. So it's a contract term that's not expressed but created in other words or conduct of the parties. So primarily an implied contract arises from the acts of the parties. The acts leading to the creation of an implied contract can vary from situation to situation. So you really have to look at the details of the particular situation to see if there is an implied contract here, and therefore not an at-will, but maybe a contract employee. Courts have found contracts implied sometimes by statements and actions made by employers during an interview. For example, it can also maybe be found in handbook terms. So be really careful if you're drafting an employee handbook, what kind of language you use to avoid the implication that that employment is not at will. They are a contracted employer. Language like something is permanent, or consider specific terms and how the language is so that it can be interpreted as you want it to be interpreted and not seen as an implied contract. Another exception is based on promissory estoppel. So promissory estoppel is similar in the implied contract claim, except that the promise, whether it's like an express promise or an implied promise, doesn't rise to the level of a contract. Remember, a contract is a legally enforceable promise, as opposed to promissory estoppel is a promise that's not legally enforceable, but someone might have harm prevented by enforcing a promise. So it's kind of missing an element that doesn't make it a true contract. Perhaps there wasn't consideration, like you have to have mutual consideration in order to have a contract, or some other flaw that makes it not a contract. But promissory estoppel is still a possible exception to employers' contention of at-will environment with this wrongful discharge or other employee situations. So for a claim of promissory estoppel to be successful, the plaintiff really has to show that the employer or prospective employer, if it was, an applicant, made a promise upon which the worker reasonably relied to his or her detriment. So you see the three elements in this exhibit. There was a promise made. They reasonably relied on that promise, like they believed them and acted on it, and then it was to their detriment because of whatever happened, whatever the result was. And then there's statutory exemptions for employment at will. So a number of statutory exceptions exist that limit the nature of employment at will. Some employers have argued that this list of exceptions makes it frustrating to have this at will rule. But the list itself is really pretty short. So employers are free to make business decisions based on managerial discretion outside of, certain judicially limited and legislative imposed parameters. So we're talking about, work safety complaints, complaints of Fair Labor Standards Act, fair pay, pregnancy discrimination, that kind of stuff. If there's no express agreement or contract to the contrary, employment's considered to be at will. So the employer or employee may terminate the relationship at their discretion. So you got to remember, this is kind of that default provision. But even where their discharge involves no statutory discrimination, breach of contract, or traditional exception to the at-will doctrine, the termination can still be considered wrongful, and the employer may be liable for wrongful discharge, wrongful termination, or unjust dismissal. And so, if that termination was not okay, they can have liability involved. So moving on, for not someone being dismissed, but another situation that's closely related is known as constructive discharge. So constructive discharge is when an employer creates a workplace environment. So this workplace environment is just so intolerable that any reasonable person would leave. So the employee's argument is like, I lasted this long, but nobody could have lasted any longer. This is just completely intolerable, and no reasonable person could stand it. So there's a situation where there's intentional targeting of the employee. It's circumstances where the employee knows that, they just have no other choice, but they have to leave. And aggravating factors that justified them, resigning from that job. There's deliberate creation of just really horrible, intolerable conditions. And there's a heavy burden of proof on the employee to establish that they were targeted, some kind of intentional targeting. And so they're the ones, again, as the plaintiff, who have that burden of proof of establishing that constructive discharge. if the working conditions are something that might consider be traditionally intolerable, so we have like a situation where there's a lot of harassment, courts have found that failure to accommodate a disability or even an employer's offers of a severance package without release of claims might be also grounds for constructive discharge in those situations as well. So going in a little bit of a different direction, we have some statutes that are other restrictions on this general at-will doctrine. And even though we talk about all these different exceptions, it's important to remember that at-will doctrine is still like the basis standard for most of these relationships. But the WARN Act is the Worker Adjustment and Retraining Notification, and it's a federal act that requires employers that have over 100 employees to receive 60 days advance notice of a big layoff or that facility closing or something. So there's going to be a lot of employees in this area that are all looking for new jobs because they've all been laid off in a big group at one time. Sometimes an affected business might choose to pay out 6 days worth of wages instead of providing the 60-day notice, citing concerns for having problems with productivity. If your job's over in 6 days, maybe you're not working as hard as you would have otherwise, theft of trade secrets, sabotaging the business because you're upset because you're about to get laid off, all these kind of things that might exist with employees. And so sometimes they choose to pay that out. We saw that not too long ago when Twitter was bought out. And a lot of people were laid off. Instead of getting that 6 days notice that they have a job for 6 days and they won't be employed anymore, they were paid severance for that 6 days of pay. And again, there's similar state laws for this kind of thing. Advance notice is the important part, so you have money to offset that income loss of losing a job and time to replace that job. We also could have wrong discharge based on tort theory liability. So a tort, is a civil wrong between individuals. It's civil wrong for where there is, a cause of action and damages at play. And employer actions against an employee could qualify as a tort when someone is laid off from their job or fired with intentional and outrageous conduct, have a claim for IIED, intentional infliction of emotional distress. If they're let go in a way that creates a situation where there's defamation based on, false statements, false defamatory statements about that employee that are untrue. They could have, an invasion of privacy situation, which could be a tort claim based on how they were let go, if their privacy was violated. And then damages can be sometimes limited depending on the state if there's workers' compensation statutes that limit damages in these situations. It's important to remember, like, damages being limited by workers' compensation statutes could particularly apply in cases where there's like physical or emotional harm suffered from this tort injury. So they have emotional distress and they have medical situations. Sometimes workers' compensation can be denied, and in those cases the employee might proceed against the employer under this tort claim, so they can seek damages where otherwise it might be prevented because of workers' compensation law. And then of course employment discrimination concepts. So employment at will, is this broad power for both the employee and the employer. But a lot of times the challenge to an employment at will situation is that the employee is being terminated for an illegal reason. So federal law prohibits employment discrimination under Title VII. So if someone is being discriminated against or having this negative employment action based on discrimination, which is, in the protected categories of race, color, sex, religion, national origin, age, disability, genetic information, other of those characteristics, things that are immutable status factors that shouldn't be relevant at all to some decision an employer is making. There's two kinds of discrimination claims that may come up in this employment context. So we have situations where we have disparate treatment discrimination. Think of this as the more common if someone talks about discrimination, that's that intentional discrimination, versus disparate impact discrimination. And that is maybe something that looks neutral on its face, like a policy or a test or something, but has an impact of discrimination as a result. So it may be unintentional discrimination, but because of this policy, because of this thing, discrimination still occurs. So going a little deeper with disparate treatment, again, this is that intentional type discrimination. It's treating similarly situated employee different because of a protected characteristic. Disparate treatment discrimination to set out a prima facie case, an employee shows they are a member of one of these protected classes under Title VII. They applied for and were qualified for a job which the employer was looking for applicants. This is in the application context. It can also apply to other things along the timeline of employment. That employee was rejected, and after the rejection, the position remained open. They continued to seek applicants, even after the rejected applicant was qualified and was not hired. When it comes to the defenses, an employer might have a defense if they have a legit reason that was non-discriminatory for why they took the action they did, so why they didn't employ someone. So it's something that's permissible, not discriminatory, that justified their decision. There might be some other reason they didn't get hired. It had nothing to do with them being a member of a protected class. It was just some other reason. Just because an employee or an applicant, potential employee, establishes all the elements of that prima facie case for disparate treatment, that's only a rebuttable presumption. So they've met the elements of that prima facie case, but then the defendant employer has the opportunity to rebut the situation. And so there could be some other explanation for why the employer did what they did. To defend against that prima facie case, and they show that there was a legitimate non-discriminatory reason for their decision. The reason could be other things that make sense in context and is not related to those prohibited criteria. Only discrimination on the basis of those prohibited categories, those things that are immutable characteristics, are protected by the law. So if the employer can show a legit non-discrimination reason for why they did what they did, the analysis doesn't stop there. So then think of it like a tennis match. So the ball goes back to the employee's court, and they can counter that defense by showing that's legitimate non-discrimination reason was just a pretext for the discrimination. So they're saying, that was just pretext. That's not the actual motive, because the actual motive was discriminatory. An employer might have a BFOQ defense, bona fide occupational qualification. So they might say, well, yes, I made this decision, but it's permissible because it's legally necessary for the employer's particular business. So it's, intentional discrimination, but it's very narrowly construed by the EEOC. So we're talking about cases where this is a legit, bona fide situation where the employer has to show that they have the basis for preferring one group over another group, because that's the essence of what the employer is in business to do, and that the predominant attributes of the group discriminated against are at odds with the business. The evidence supporting that qualification has to be credible, legit, not just the employer's opinion. And the employer must be able to show that it would be impractical to determine if each individual member of a group who was discriminated against could qualify for the position. So, because it's kind of almost like a legally justified discrimination, we're looking for, legit reasons that, again, are very narrowly construed, and it's never going to be available in race, because race can never be used as a bona fide occupational qualification. It might be other situations that is, a legit part of that business. For an employer to be successful in their defense of, a BFOQ, they have to show that it really is important for that particular business, that they have this legit reason. So they have the burden of proof that they had reasonable factual cause to believe that, all or substantially all members of a particular group would be unable to perform, these safe and efficient whatever duties of the job that were involved. So this is most effective an employer has consulted with an expert in this area who has some kind of good, scientific basis for belief, because there's a two-part test that's got to be answered for them to kind of show this defense. Does the job require that the employee be of one gender? If the answer is yes, is that reasonably necessary to the essence of the particular business? So there might be particular reasons that a business needs someone of a particular gender, like to be an attendant in a fitting room or in a locker room at a gym or something. But they have to show that it's very narrowly tailored. There's only going to be certain kinds of things that are going to be exceptions for this. And that's what this two-part BFOQ test is. Does it require like this is, the test for gender. Does it require the employee be of a particular sex only? And so we can do this to other characteristics too. This is just the example based on gender. And if the answer is yes, is that requirement reasonably necessary to the essence of the business? Because sometimes there have been cases that have been where someone says this is important, but then they couldn't prove that it was reasonably necessary to the essence of the business. The example that I have here is, the Playboy Club's business. They were able to justify hiring women only because it was essential to their business. However, Hooters was not able to justify women only as servers because their primary business was serving, chicken wings. It's a restaurant, drinks, that kind of thing. And so there was a difference between their marketing versus business essence when justifying whether or not, because they both had similar cases brought against them with prospective employees that were male that were being completely, not even considered. And in the case of Playboy, they were successful in their claim that it was important to hire women for this role. And then in the case of Hooters, they were unsuccessful in their claim that it was essential to hire only women for their role. So looking more at unintentional discrimination, we call that disparate impact discrimination. That's discriminatory effect of something that looks neutral on its face against, that causes discrimination on someone that's in one of these Title VII protected classes. The policy in and of itself doesn't seem to be discriminatory in nature, but the result is that it results in discriminatory action. So, court cases have seen some of these kinds of situations where they have disparate impact, but it's important to understand that a screening device that has a disparate impact doesn't always mean that it'll automatically be struck down as discriminatory. If that screening device is legit, it's part of a business necessity, then it will stand. So, we have this screening device in hiring. Maybe there's a test, like you've got to be able to carry a 50-pound bag 100 feet in a certain amount of time or something like that. If that is an important component of that job, that test is legit. But if they're making every single person for all kinds of various roles go through that test, and maybe someone's applying for a role that doesn't necessarily need to have that skill, it could have an impact on people that are not able to pass that test because of their sex or because of something else, and it's not even essential to the role. When these screening devices exist, the rule is that 4/5 rule, a minority group must perform at least 80% as well as the majority group under that screening device. That's kind of just a rule of thumb. If the requirement is not met, the presumption arises that the screening device has a disparate impact on that minority group. And so in order to defend against it, the business has to show that it serves a legitimate business necessity. So let's look at the next slide for the defense that a business might have. So the employment discrimination, disparate impact, what's the defense from the employer? Well, one of the areas that we're going to, address in the issue of disparate impact of screening devices is, subjective and objective criteria are concerned. Objective criteria are the factors that are able to be quantified by anyone. So like if it's a written exam score, right? Versus subjective, which is qualitative criteria, are factors based on an evaluator's like personal thoughts or ideas or opinions. And so initially it was suspected that subjective criteria couldn't be the basis for a disparate impact claim, since the Supreme Court cases had involved only objective factors like height, weight, education requirement scores, test scores, stuff like that. But again, business necessity defense is going to be the defense to disparate impact cases. The employer has to show they have a need for this policy. This is a legitimate job requirement. So even though the result, when you look at the math and the statistics, it might show that it's having a impact of discrimination unintentionally. If the employer can show that it is necessary for the business, again, like a lifting requirement for a certain amount of pounds or something, then it might be justifiable. And also part of this, is going to be looking at, was there an alternative to the screening device use? So this screening device, had this impact of discrimination on this group, but is there something else that could be used instead that might have a less discriminatory impact? So here are some landmark cases in kind of defining discrimination cases in the Supreme Court. They're in your textbooks. I'm not going to go over them right now, but also it's important to realize that, there's other defenses an employer might make that the employee's evidence wasn't true. That the claim that they're making, they have the burden of proof and persuasion. So just like in other civil cases, it's that preponderance of evidence standard. So think of the seesaw. It's got to be more likely than not. The key is equal opportunity, not equal numbers. And that's why there's that range of, 4/5 type rule, 80%, whatever, because no one can ever expect it to be exactly, the statistics come out perfectly even. So essentially what it comes down to is that employers' policies should be designed that in a way that they ensure that everyone has an equal chance at the job based on their qualifications. An employer has all this performance they can consider for an applicant, and people need to make sure that they're careful about these kind of screening devices and things that are appropriate in the employment context of how they're deciding who has met this criteria and things like that. There's some other concepts that are important to consider. Accommodation cases. So the employer has a duty in certain situations under both, the Civil Rights Act, Title VII cases, and under the Americans with Disability Act claims to seek accommodate workplace issues to help make it more suitable for the employee. There's a limit to this. It's not unlimited, like the employer has to do whatever they need to do to accommodate. But they need to do what's reasonable as long as it's not causing undue hardship. So reasonable accommodation for things like religious accommodations or disability accommodations. Also, it's important to know that Title VII specifically includes provisions allowing employees to file separate claims for negative consequences they experience from pursuing their legal rights under Title VII if they experience retaliation. So even if the substantive claim of discrimination is not proved in court, so they claim discrimination and maybe they lose on that claim, they can still win on a retaliation claim. So they can still say, I felt like I was discriminated against. I brought this action. I didn't win my case for this action, but as a result of this action, I was retaliated against at work. This whatever situation happened. That's what an employee can bring as part of their case. So retaliation is not excused even if this underlying discrimination fails. That behavior is still not justified. And then, exhaustion of administrative remedies. So statutory schemes are set out for employment discrimination claims require that the claimants, pursue their grievances with the EEOC first. They're the ones where they have to start before they file a lawsuit in court. And so all the protective statutes provide for courts to hear employment discrimination claims only after the claimant has done all that they can be done at the agency level. This is known as the exhaustion of administrative remedies. So they're supposed to exhaust those administrative remedies before they can sue in court. So in this exhibit, we have the basic remedies that are available. And the basic remedies for discrimination cases. And sometimes there's statutes that might have additional remedies, but these are just the basic ones that discrimination cases might have available as remedies. They can, an employee that is successful in their claim, they can claim back pay, they can front pay that they lost out on in the future, maybe reinstatement for a job, they can reclaim seniority, retroactive seniority, they can get an injunction, compensatory damages, punitive damages, and potentially even like attorney fees, or if there's medical costs because of an injury suffered. Here's an illustration that defines kind of what these terms are. And so it's important to understand that under the law there are certain caps for damages that exist, and they're kind of different depending on the size of the company, basically how many employees are working in the company. These caps are dependent on the number of employees that an employer has. Juries may not be told of the caps on liability. Since race and national origin cases can also be brought, under Section 1981, these permit unlimited compensatory damages. The caps aren't going to apply in those categories. About 20 years ago, the Supreme Court also ruled that though compensatory damages are capped by the law, the limitations don't apply to front pay. Also, the Supreme Court's case in the Hoffman decision foreclosed the ability of undocumented workers to receive post-discharge back pay, and the EEOC rescinded its policy guidance suggesting otherwise. So how do you find additional legal resources once you've been exposed to the law, or this area of law has been included? This section of your textbook going on in the additional legal resources section of this chapter help you understand how to search for additional information if you have the need. These resources are now available to people all over, so you can be informed much more easily than you could in the past when you needed to go to a law library. Law libraries are found everywhere. Sometimes large private law firms have great law libraries. Public courthouses typically have some kind of law library somewhere in there. Law schools here in Metro Atlanta, there's a few different law schools that have law libraries that people can go and access information. Traditionally, that is where a lot of people used to get information. But nowadays, with the internet, there's so many databases that are available for public consumption, and so many legal scholars that write about things. There's links to different states and what their laws are, and links to, Supreme Court decisions, and then a lot of analysis of legal scholars on what those decisions really mean or what the impact might be. So most of these resources are easily available on the internet. Sometimes there's fees involved because there's subscription services or something like that. But there's a list in your textbook of these kind of services that are available. Okay, so of course we want to think about management tips for your future careers, or maybe even your current careers. But it's important with these management tips that you always remember that you're supposed to be hiring the best person for a job. If you're in a position of hiring, hire the best person for a job. That is always going to be justified. The law is stating that somebody can't make this decision based on prejudice or stereotypes. In order to avoid, wrongful discharge suit, and more importantly, to ensure the ethical quality of your decisions, don't fire somebody for some reason that violates basic principles of dignity, respect, and social justice. Make sure that the policies and procedures create a safe space for employees to voice concerns and complaints. It's effective for employees to be able to share these issues. If you're the employer, a leader in the business, that they can come to you with these issues long before they reach a breaking point. Then make sure that everyone knows about these issues and have appropriate training to train people how to act and how to be appropriate in their roles. There's lots of legal resources now available to help keep up with a lot of the changes that happen and regularly take place in the employment law arena. So that's important to help businesses stay in compliance with what the law, and as the law changes, continue to stay in compliance. Some of the things you're going to learn about in this course could change quickly. Some of them might stay in place for a long time, but it's important that you have this foundation and you know how to follow changes in the law and stay up to date with things. And again, monitoring policies for potential impacts and compliance issues, and update those things as needed. And this is the end of chapter 2. So in summary, this is a toolbox chapter that helps you understand the legal system and its processes, some common anti-discrimination concepts, and the basic concept of at-will employment and exceptions to at-will employment. Understanding that decisions could have significant consequences, and the difference in the types of discrimination claims for intentional or unintentional disparate treatment or disparate impact discrimination, and the important defenses that employers have to each, and that retaliation claims are common. They're continuing to rise. It's important to take care to avoid actions that could, trigger such claims, including from other employees.